a dispute occurred between the European Union and the Republic of Korea under their FTA in December 2018. The European Union requested formal consultations with Korea concerning some provisions and practices of Korea's Trade Union Act, which the EU considered to be inconsistent with Korea's obligations related to multilateral labor standards and agreements under their FTA. The unsuccessful consultations led them to convene a panel of experts, making the first case in reaching that final stage. The panel of experts partially agreed with the EU, thereby leading to the first case in history in which a breach of modern labor provisions in FTAs was found. Free trade and investment, the spearheads of globalization, are often considered as a threat to quality jobs and welfare states. Beginning in the mid-1990s, the United States, the EU, Canada, and other advanced nations signed bilateral and regional trade agreements that include terms and conditions on labor and environmental standards, human rights, and governance. In July 2020, the US, Mexico, and Canada signed a historic trade agreement with presumably the strongest and furthest-reaching labor provisions. The agreement, in addition to conventional labor protection mechanisms, requires Mexico to reform its labor laws before the agreement takes full effect and specify the minimum wage in the passenger vehicle industry to be $16 per hour. Compliance with the freedom of association and right to collective bargaining will be monitored under a special enforcement mechanism, and any violations of specified labor standards may result in trade sanctions, including the scrapping of tariff benefits. Like a double-edged sword, however, labor provisions in FTAs could be misused as a geopolitically strategic tool or for protectionist purposes. Against this backdrop, the Trade Union and Labor Relations Adjustment Act was amended during the EU-Korea FTA dispute. Here are some of the highlights of the amendment. Trade unions may decide membership eligibility regardless of their organizational form. Eligibility requirements for trade union officials may freely be set by the union's bylaws. For enterprise unions, union members employed by the enterprise can be officials of the union. All union members, whether or not they are an employee of the enterprise, are entitled to enter its premises and participate in union activities insofar as such activities do not hinder business operation. But it remains controversial whether the amendment fully addresses all the issues that the panel of experts in EU-Korea raised. The Korea-US FTA and Korea-Canada FTA also contain labor provisions similar to the provision disputed in the EU-Korea dispute, and they are equipped with a stronger enforcement mechanism that ultimately allows for trade sanctions and monetary assessment, respectively, for a violation of labor provisions. This means there still remains the risk of a similar dispute with another trading partner. Amid these changes, the steps taken now are critical for the future. First, we need to strengthen our efforts to comply with labor provisions in FTAs and closely monitor our major trading partner countries on any movement that could enhance the link between trade and labor, including reforming anti-dumping regulations. In addition, we need to make ongoing efforts to fill the gap between our labor law and practices and international labor standards. We also need to be prepared to take legal action against unfair or unlawful claims regarding labor provisions. Lastly, we must be proactive rather than passive regarding labor provisions. For example, by developing our own labor provisions that can serve as leverage when negotiating for and signing an FTA with new trading partner countries. In the sustainable world we aim to achieve in the 21st century, trade and labor cannot be separated, and trade issues will always involve labor and environmental standards and human. International trade is a matter of survival for a nation that is as export-oriented as Korea. The FTA dispute over labor provisions can serve as a momentum for Korea to play its global role as an advanced country by reforming its labor law and practices. We must adjust quickly to the global trend and make improvements to make full use of it in the trade negotiation with a strategic attitude.